afternoon or evening, everyone, given the turn of the talks back. Thank you all for attending the latest U-Party webinar on the impact of GDPR on clinical trials. Tonight, I'm very pleased to be able to introduce Charles Helleputte, who will be giving the presentation, and he's been supported by his colleague Diletta De Chico. Diletta is an associate at the Mayer Brown Brussels office. Her practice focuses on privacy and cybersecurity. Diletta advises clients regarding a wide range of global data privacy and security issues. She assists in organizations in complying with EU and national privacy laws, including developing global data transfer mechanisms, privacy statements, data breach notification policies, and procedures. Diletta regularly publishes articles on those matters and is a speaker on such topics. So we're very privileged to have her help create this presentation for us today that I know has also been pulled together by presentations that have been given to a number of other different locations, including those within the pharmaceutical setting. And Charles is a partner at Mayer Brown and heads the cybersecurity and data privacy team in Brussels. Charles is active in a number of sectors, including hospitality, finance and insurance, travel platforms, aviation, infrastructures, as well as health, and a range of practices advising clients on global data privacy and security issues, assisting in dealing with data breaches, counseling on regulatory developments, data privacy aspects of employees monitoring and investigations. You can look up both of them on either the Mayer Brown profile page or on LinkedIn if you have any other questions as to their profiles and backgrounds. And so I'm very, very happy to be listening to this presentation today. Although I myself have had to delve into the whole GDPR topic as part of making U-Party GDPR compliant, I'm very interested to know about GDPR and the wider clinical trial setting and how it just impacts all the other different areas to expand my own knowledge as well. So Charles, please go ahead and take it away. We'll be having questions not only at the end this time, but also at periodic points throughout Charles's presentation. So we have everyone on mute, as is the normal practice within the U-Party webinars. If you have a question, please go over to the questions box and type it, and I'll be picking them up throughout the presentation and addressing them to Charles. And if we have a more specific question, we will, of course, unmute the person asking the question for a wider discussion. Thank you very much for all attending. Charles, the floor is yours.
Hi, everyone. Thank you to EU-Party for giving us the opportunity to speak to you all today about the impact of GDPR on clinical trials. Let's say first that the good things with GDPR is that it's known to almost everyone, because most of us received prior or close to May 2015, which is GDPR Day, most of us received those emails asking for consent or reconsenting on receiving some of the data. I'm told that some of you might have also received those as part of your membership to EU-Party. Here, really, the idea for this presentation is to focus on GDPR aspect around clinical trials. You will see that, of course, in the limited time we have available, we will try really to only get to some aspects. Happy to take questions on those or on many others. But before we kind of jump into the subject, just let's keep in mind or remind everyone about what GDPR changed as from the 25th of May. Of course, as you know, the idea was to develop and put in place a new framework for the processing of personal data. And it comes with really an increased burden, if you want, on many actors dealing with your personal data. So it first stands for increased data privacy governance requirements, with people having to communicate much more extensively about what they are doing with the data. It's also a strengthening of the individual's rights to personal data. On a side note, one may question if individuals will in fact exercise those rights, but at least they are we are all be given rights to exercise against data controller or processor, asking them why they are using our data. The GDPR also has or requires some information to be given to data subject at different point in time. For example, upon collection of your data, but also if something bad or wrong is happening with your data, like a data breach. It impacts or implies that everyone has policies, procedures, and contractual framework in place to ensure compliance with the regulation. And GDPR is known for that, although we haven't seen yet very high fines, but it's known for a fine potential, or at least some reputation risk for non-compliance. And that's probably what has governed the most efforts around GDPR compliance, is the fear to get pointed out if something is going wrong with GDPR compliance. What is important to our context is that one of the purpose of the regulation was to give more harmonization across the EU member states on data privacy. But one should keep in mind that member states still have some discretion in a number of important areas, and health, as we will see in a minute, is one of those areas where member states have kept some bargaining power. For example, member states can decide what they are going to do with data of deceased persons, so whether those data will be concerned or subject to the regulation, whilst in principle they are excluded from the text. Member states can also add some more burden when you are dealing with health data. For example, requiring the appointment of data protection officers in some instances, or requiring disclosure of list of persons who will have access to the data. So although the objective of the regulation was to bring harmonization, in the health area, unfortunately, harmonization is probably a bit overstatement, and you will still have to deal with local or national laws in a number of contexts. And we will see that in the clinical trial context, this brings its own complexity. I'll discuss GDPR for the next 25 minutes or so. And of course, GDPR is important, but there is not only GDPR who is important. First, so GDPR is important because the clinical trial regulation cross-refers to data privacy laws in a number of its provisions. And the interesting things here, just on a side note, is that it still refers to the old directive, simply because at the time the regulation was adopted, GDPR was not yet there. But if you look, for example, at Article 93 of CTR, so of the clinical trial regulation, you will have a reference there to data privacy laws, saying basically that all of the processing needs to comply with GDPR rules. You will also have, for example, in Article 28 of the clinical trial regulation, a reference to the fact that a clinical trial can only be conducted where data privacy is safeguarded, and that means complying with the regulation and domestic laws. Further on, if you go in what a dossier needs to look like, and you go to Annex 1 of the CTRs, you will see that is required a statement of the sponsor of the clinical trials confirming that compliance with the regulation, so compliance with the GDPR or privacy laws will be respected. And there we are told that there are some templates who are being developed, for example, and I will question in a second the kind of rationale behind that sponsor statement, especially in cases where the sponsor is not the only controller in a trial. That's why GDPR is important, but as I just mentioned, there is not only GDPR. There are a number of other rules and regulations that needs to be considered, and I'm just going to list them today and not dig into any of them in a great details. But as you know, in addition with the regulation, we have also the regulation 45.201 on the processing of personal data carried out by the Commission, the EU Commission, and the EMA, for example. That is very relevant for the principles that govern, for example, part of the processing of the portal as part of the CTR setup, with sometimes some mix and interplays between that regulation and GDPR on things like, for example, databases that are held by some member states, and in addition to a database that are held by the agency or the commission, with meaning that you have multiple layers of regulation applying to those data. In addition to those kind of purely privacy-related instruments, you have others. The NIS directive is one that is kind of governing cybersecurity, if you want, or IT requirements in a number of sectors, and health is one of those sectors that needs to comply with the directive and the implementing law. On the NIS front, for example, beginning of November is the deadline for member states to identify those operators that are considered as providing essential services, meaning that those will have to deal with specific requirements. Some things to watch out as well. And then two others that you need to consider or keep an eye on is the upcoming e-privacy regulation, if it's ever adopted, that is dealing with things, for example, like Internet of Things, or in your sectors, what we call Internet of Bodies. So all of those components that are put into the body, but that they can speak to the Internet and exchange and share some data. If you take things like remote clinical trials, for example, it's an area that will be subject to GDPR requirements, but also to some extent to these e-privacy regulations. I'll finally mention the upcoming EU Cybersecurity Act that is dealing more on cybersecurity resilience and certification of process, product, and services. Also something that is relevant in the context of health. With that, as a kind of introduction, let's now start and focus on the impact of GDPR on clinical trials. As I mentioned at the beginning, we will focus for today on three main topics, and those three are those listed on the slide. So first is what GDPR is bringing on the role of the parties to a clinical trials and their responsibilities, some of the new governance obligations, and of course, a focus on the impact of the regulation on the legal basis for processing. Really, the idea each time is to kind of bring you up to speed with the change of the regulation, and then list really what is the impact. So between no impact, moderate impact, of high impact. And then subject to the time, we will also share with you some lessons that we learned from the management of data breach. So for all of those who were expecting today to cover, for example, things like the EMA transparency guidelines and recommendations, so unfortunately that's not the topic of this discussion. As I mentioned earlier on, if you have specific questions around those, feel free to raise them in the end. But the topic for today is kind of focused on those three selected aspects that are the most relevant, if you want, when we discuss the new framework. Let's start with number one, which is the role of the parties. As you know, the regulation kind of made a summa divisio between two different roles, excluding the data subject, of course. The first role is the one of controller, and the second one is the processor. What we have tried to do here in this slide is to show the difference between a controller and a processor, so the different kind of duty or requirements that are applicable to each of them. And we'll then plug that into the CTR framework if you want. If you look at the regulation, the definitions are relatively easy, and they haven't really changed dramatically compared to what we had in the directive. A controller is the one deciding on the type of data that are collected and the reason behind the processing. And the processor is the one who is processing on behalf of an instructing party, the controller, the data or a number of data. That's kind of simple and easy, but then what is more interesting is to see what GDPR is bringing as role and responsibilities for each of them. First, both or each of controller and processors needs to have appropriate technical and organizational measures, including security, to make sure that they are developing a comprehensive framework depending or based on the type of data they are holding and processing. If you are interested, you can see the reference to the GDPR provision there, but basically it's a number of security measures that needs to be taken, and you will see in the provision that every time there is a kind of proportionality between the type of data you are holding and the measures that you are expected to take. In an area like health, of course, you are dealing with sensitive data, meaning that the expectation on the standards and security measures that you will have to adopt will probably be higher than in other type of sectors. That is the first type of requirement applying both to controller and processor. The same applies for the need to have policies and procedures in place, including a register of processing activities. That is, if you want, just a initial reflection to be done by every party to explain what and how they will be handling data. Trying to have policies and procedures that are just copied from what you have seen done by someone else is probably not very helpful. So you really need to have those policies and procedures developed according to your own realities. And we have seen some examples of organizations that were fined most or more because they had procedures that they weren't following, rather than not having any policies at all. So here really the message is, okay, you need to have those policies in place. You need to have a number of procedures, for example, just to be able to deal with subject access requests, but those need to be tailored to your organization, and they apply both to controller and processor. The same applies for the need to have a data protection officer. And as you know, so the data protection officer is a kind of super responsible person that needs to be consulted and have some things to say on everything around processing of data. It's one of those areas where member states can take some strengthening or stronger position than the regulation, and it's probably fair to say that in your sector, having a DPO will either be required under domestic law or probably be a very good practices to have, even if it's not per se required by the regulation or the domestic law. Something that is only relevant for non-EU related controller or processor, and of course you can think to, for example, a controller or processor based in the US, but we can think maybe to a processor or a controller based in the UK with the upcoming Brexit. Is the requirement to have an EU representative. So it's someone in the EU that either the data subject or the authorities can tap into to inquire a controller or a processor that is not based in the EU. Because as you will remember, one of the big change introduced by the regulation is the fact that it has an extraterritorial reach. So basically that if you are not based in the EU, but processing some of the data of data subject located in the EU, you are caught by the regulation. Both controller and processor need to cooperate with supervisory authorities. That's one of the big change introduced by the regulation, because under the old rules, under the directive, only the controllers were possibly subject to direct contact of supervision by the data protection authorities. Here, with the regulation, even processor can be investigated, fined, and have responsibilities vis-à-vis the authority. That's the kind of common ground, if you want, and then you move to specific requirements that are only relevant or applicable to controller, and those are items such as defining the legal basis for processing, a topic that, of course, is very relevant in the health area, and we'll come to that in a second. The need to inform data subject, because as you know, one of the key changes of the regulation is to bring more transparency in the way we process data and the way we inform data subject that their data are processed. Also something that in the clinical trial context is a real challenge for many actors. The same with dealing with subject access requests. That is something that is only applicable to controllers. They are the one who needs to reply to subject access requests. The same for other things like the need to have data protection impact assessment, meaning some prior checks and homework, if you want, when you are dealing with sensitive data. You need to demonstrate that you have taken steps to mitigate the exposure, or that you have put in place the right level of safeguards to mitigate any potential exposure for your data subject. The same for the need and the requirement to have privacy by design, so trying to factor privacy in everything you do. Also, a requirement applicable to controller, dealing with data breaches. Of course, and as we will discuss in a second, we will see that everyone can have a data breach, so either the controller or the processor, but the one who is liable to notify the data protection authority or the one which is liable to communicate high-risk data breach to data subject is the controller and not the processor. Last set of requirements, very important, is the need to have a written agreement with the processor to detailing and explaining what is going to be done with the data. That's something that as a controller you are required to do if you want to demonstrate that you have taken all of the necessary steps. If you look at Article 28, you will see that Article 28 mandates you to have a number of provision in a written agreement with processor. I invite you, of course, to go and look at those. And now let's try to see what all of those new requirements and what are the impacts for in a clinical trial context. As I have mentioned here, so I've just mentioned that we have two roles, controller and processor, and describe admittedly relatively quick what role and responsibility everyone has. What is important to know is that the GDPR introduced a new concept, is the concept of joint controllers. So it's basically a new definition that is supposed to govern situation where you have two controllers deciding together the type of data they want and what they want to collect and the purpose of that collection. And what we have seen as part of the preparation of GDPR is that, of course, and I said, of course, it's a bit sarcastic, but what we have seen is that a lot of different authorities have taken different approach in the way they consider the role and responsibilities of parties to a clinical trial. Let's start with the good news. The good news is that it's kind of commonly accepted that the CRO will kind of always be a processor. That's kind of clear. The sponsor is also kind of always be considered as a controller. That's also kind of a given. Where it's much more complicated, or where we have seen a different approach taken by different authorities, is on sites. Because we have seen positions where sites were considered either as joint controller or as controller on their own rights, so not joint controllers, but just a different controller, or processor. And you may think, okay, so why is all of that relevant? It is very relevant because, as I kind of have mentioned here, the quality you have has a huge impact on your responsibility. And if we put that into the context of CTRs, that has an impact on the documentation. Because the way, for example, you will describe what you are doing with your data in your ICF will be different if you are a controller or a processor. Some of the provision and around what you are going to do with the data, they will be very different if you are confronted with a controller or if the site is a processor. For example, as we have seen, in case of a data breach, it's the responsibility of the controller, so the sponsor at least, to communicate to the authorities and eventually to the data subject. If we are now in a country where sites are also considered as controller or as joint controller, then you will need to have in your agreement with the site, you will need to have provision detailing how you will be managing between the sponsors and the site, how you will be managing the data breach reporting and the communication to data subject. If we want to give to that a kind of another perspective, you need to keep in mind that as a controller or as a processor, you will be responsible and liable in your own right. and that will be based on your own assessment of your situation. Of course, when you are launching a clinical trial, you are not that much concerned by complying with GDPR. Of course you are, because you know that it's important and that needs to be done adequately. But what you want to do is to start launching the process. And to do that, very often, you will be using ethical committee templates that have been designed according to the view of what the ethical committee will consider the role of each of the parties. If you need to subscribe to one of those templates that is, for example, considering the site as processors, whilst you will be dealing with a site that is considering itself as a controller, you will see, or you can imagine that will directly raise some difficulties, and it will raise even more problem and issue by the time that you are dealing with your authorities. Because of course, you will be assessed by your authorities depending on your own situation, and you will hardly be able to say, okay, I'm sorry, I'm not responsible. I've just used the forms that were required, that I was required to be used, so you shouldn't blame me. I've just done what I should. That's not something that will happen. So that means that, for example, in cross-border clinical trials, depending on the vision that each authorities will have and develop, you might just be confronted with a different situation. I'll pause here and let Matthew see if we have questions up to now. Otherwise, I will then be moving to the next topic.
Thank you very much, Charles. Yes, we've had a couple of questions since the start. Focusing on the start initially now, we've got two particular questions around one of your first slides where you talked about the fact that EU GDPR was not the only piece of legislation in this area. And the first question is, obviously, you talked about e-privacy and you also talked about the Cybersecurity Act. What are the timelines that we expect to see on having them brought into law or into implementation?
Yep, so that's a very good question. The one who can bet 100 euros or pound on when e-privacy will be adopted is a good one, because let's say currently the indications are that it's unlikely for e-privacy regulation to be adopted before the end of this term of the Commission and Parliament. So that one is likely to slip up to the new Commission, and so it will probably be something like end of 2019, early 2020. For Cybersecurity Act, we are more confident. Work there has progressed quite extensively. So that one might still be adopted prior to the end of this term. So we might have Cybersecurity Act early 2019.
Okay, super. And so in a space where all three will then exist in the future, they all govern very similar aspects of the same thing. Is there a risk of some conflict between the three pieces of legislation? And if that would occur, which one would take priority over the other?
Yep, that's also a very good question. I don't think that we will have too much of an overlap between Cybersecurity Act and e-privacy and GDPR, because Cybersecurity Act is kind of much more targeted to resilience to cyber risk. So it's that is kind of bringing a new type of environment that we hadn't so far into the EU world, much more US driven, if you want, because in the US they take cybersecurity much more seriously for much longer than we did. So on the Cybersecurity Act will have an impact on the way we should think to our product, processes, and services, but not too much risk of difference or overlap with the two others. On potential overlap between e-privacy and GDPR, that's exactly at the kind of heart of the difficulties between or with the current e-privacy project, because e-privacy is lex specialis to GDPR. So GDPR is the kind of umbrella, and e-privacy is one little piece of that one. And what they are trying now during in the negotiation is to exactly try to avoid situation where you will have e-privacy provision that doesn't work well with GDPR.
Okay, very interesting. Then moving on to this idea of obviously the controller and the processor, we've got a couple of questions around that. The first one being, in a situation where we'd see a joint sponsor research study, do they both have to be joint controllers, so to speak, or can they delegate the responsibility of controller to one or the other?
Yep, so on their face, they are likely both to be controller and joint controller, but that's as such, so it's important because they will, each of those will have their own liabilities, if you want, towards both data subject and the authorities. But the good things there is that under GDPR, they are required to agree on how they will be dealing with GDPR compliance. So it's perfectly possible to have in an agreement a kind of common understanding between the two sponsors, and for example, having one of the two taking care of all of what is related to dealing with data subject, for example. One can be mandated to take care of all of that. But they will need to agree together on their respective role and responsibilities.
Super, thank you very much. And the last one in this series of questions is again on the subject of controller and processor. And Estelle, Michael is asking, there's a conflict in the interpretation, I guess, between controller and processor. Just wondering if there'll be further guidance from possibly the Commission on how to define between one or the other, or do you think it'll come down to a decision by the European Court of Justice eventually?
Yeah, let's say that on controller versus processor guidelines, we don't expect new guidelines on that topic from the EDPB, so the European Data Protection Board. That is the one that has kind of replaced the Working Party 29. What we have seen, and that is probably even more confusing, is that we have seen different authorities starting to develop their own little guidance on what is a controller, what is a processor, especially in the clinical trials area. And I think you rightly point that if we keep having an unharmonized approach, the likely solution will come from a case we will have from the Court of Justice, the issue being that if that needs to happen, we'll probably need to wait 2, 3, 4, 5 years between no and a potential resolution.
Very good. So there are a couple of other questions, but I'll leave that for now, and we'll continue with the presentation, and we'll circle back to them later, just conscious that we make the best use of the time.
Okay, wonderful. Thank you. So let's now move on the new data governance obligation, and that one will probably be quicker than the first part. And really the idea here is just to identify all of those new governance obligations that GDPR is bringing to try to make sure that everyone is aware of them and knows what it's all about. The first one, and I kind of covered that already, is that the GDPRs and domestic laws will require public authorities, but also organizations that are carrying out intrusive processing activities to formally appoint a data protection officer. That is the one responsible or that you need to consult with everything that is related to processing of personal data. The kind of very big change that GDPR has been bringing in is the requirement to notify data breaches to the authorities. So when you have some intrusion or your system, or you lose some of the data, you are required to notify the relevant European data protection authorities within undue delay and where feasible within 72 hours of the breach. The health sector is one, along with regulated industries like bank and finance and some of the hospitality industry as well, is one that is the most subject to hacking, malwares, and everything. And really dealing with those security breaches has been something that has taken a lot of effort and energy since GDPR Day. In addition to the requirement to communicate to individuals that may have been affected when you are dealing with health data, of course, by the time you are losing some of your the data in relation to one of your patients, you can imagine that that one will be high risk, and that you can assume that you will have to go and tell them that something went wrong with the data. That is, of course, something that requires a careful preparation by everyone, and that GDP is probably one of the non-sympathetic, if you want, consequence of GDPR. Amongst the other requirements that GDPR has been bringing on the table for governance is the need to conduct, prior to any processing activities that has a potential high impact on data subjects, to conduct what is called a data protection impact assessment. I'll not going in much more details here. Happy to take questions if you have on that one. The need and requirement to factor privacy in everything you do. So in the contractor you will use for conducting one of your surveys of your patient, in the new system you will be using to centrally manage all aspects of the trials, everything there. You need to be thinking of privacy and need, for example, to only use vendors that have taken steps to show that they can comply with the regulation. The last one that is also very relevant, and to some extent that hasn't changed much because you were probably already required to do that before the entry into force of the regulation, is the need to maintain a detailed record of processing activities you are carrying out. So basically, knowing the type of data you are holding and what you are doing with the data. Frankly, on the governance side, the impact of GDPR is probably, as we put here, it's probably moderate, because a lot of those things were already, if not required, but done as best practice before GDPR. So there, hopefully, the regulation is not bringing too much of a change for organization. And here, Matthew, I also let everyone maybe give opportunity to raise question in that specific area before moving to the legal basis for processing.
Super, thank you, Charles. So we actually have a very good question here related specifically to data breach. And does such thing as an insurance exist for data breaches? And is it something that you've seen processing, or should we not say processing side, that you've seen organizations requiring to have of people who are storing data, for example, like registries?
Okay, so On the first piece, on cybersecurity or data breach insurances, let's say there are two different aspects to that question, I think. The first is there such things like a cyber or a security incident insurance? That exists. And you have some providers out there that have kind of specialized team in the even in insurance company that will, for example, when you are confronted with a breach, help you to take some of the steps to mitigate the breach, help you in, for example, appointing a forensic investigators or some technical experts to look and see what the breach is all about. So that exists. What is much more debated is whether or not the fine that you might receive from the authorities if you are not managing the breach properly, whether that fine that you might get is insurable. And that is much more questions. So I'll just put my doubt on whether or not you might be covered for, if you want, some of the consequences of the breach. That is much more debatable. And I'm not sure I got your second question, so I'm sorry for that.
So the second question then related to, have you actually heard about people requiring a data breach security of data holders, for example, registries?
Yeah, so there, let's say that as frankly, as part of the due diligence process that you conduct when you start to frame and organize things like a new trials, for example, we have seen due diligence on security aspects. And there, I think I made the point when I discussed the different set of rules and that you need to have to show and demonstrate compliance. It's one thing, for example, to be able to show that you have a policy to deal with data breach, but very often you will receive some more questions to make sure, for example, that if indeed a breach is happening, you can deal with it and have process in place to actually have the policy working in practice. And that goes as far as that, because people are aware that data breaches is probably the most critical aspect you will have to be dealing with as part of your ongoing compliance.
Right. Thank you very much for answering that. We also had a question slightly earlier about, in the situation where you have data being collected, I guess multinational trials, where data is being collected and processed in multiple areas, perhaps in the EU as well as outside of the EU, what's the minimum that needs to happen there according to GDPR?
Yeah, so that's also a very good question. I'm not sure I can answer that in a very simple way, but I'll do my best. Let's say that some of the challenges that cross-border processing will raise are probably twofold. So first, it will be important to determine for each of the processing actors or organization, if you want, to which rules they are subject to. That's one. And so whether or not they will be covered by the GDPR and in which capacity, because that means then different requirements depending on who they are. So that's kind of level one. And then level two is, of course, by the time you are sending data out of the EU, all of the discussion around appropriate transfers mechanism will need to kick in. And that is an area that is currently very challenging, because a lot of the transfer mechanisms that are available or that the regulation provides for are a bit at risk for the moment. And I'll just mention that briefly. For example, amongst the different transfer mechanisms you have available, if you are using a processor, for example, in the United States, we had or we still have the EU-US Privacy Shield. Currently, the EU Commission is reviewing whether that kind of framework is adequate and offers the right level of protection for EU data. And we'll know by the end of November, early December, what's the statement there. Another kind of transfer mechanism available is what we call the EU model clause. Those are subject to a judicial process and will be reviewed by the Court of Justice probably in the course of next year to see how adequate they are. So you see that for that second layer, so transferring data out of the EU in a way or another, all of that is an area that is currently subject to a great level of uncertainty.
Does this mean that we see when trials are getting designed or set up that by design there's almost two levels of data existing? The data that is gathered outside of the EU and not subjected to the EU legislation, assuming we're not processing in the EU, and those that are gathered within the EU. So almost two different classifications of data, one with many more rules and obligations than the other.
Yeah, and although that's I think the reality is even more complex than that, because, for example, in international type of processing or trials, what you will have is needing to deal with multiple frameworks, and to some extent, one of the approach we have seen taken is to use GDPR as the standard, if you want. So applying GDPR in all circumstances, even when you are not required to do so, just to make sure that you are kind of dealing with what the EU consider at least the most or the higher standard in everything you do, to at least show that you have taken the things carefully.
Super, let's continue at that point.
Okay. And I'll move to the next part and the final one, subject to having some time to discuss the data breach. But the last piece deals with the legal basis for processing. Of course, that's an important subject because, as you all know, you can only collect and process data if you have a available legal ground for processing. When we are dealing with health data, we are clearly falling within that kind of specific category that we call special categories of data. And for those, as we know, we have less available legal grounds that when we are processing non-special categories of data. Here as well, unfortunately, it's an area where member states do have a lot of maneuver, if you want, to provide for additional limitation, and we'll try to navigate that in the slides to come. Before GDPR, consent was considered as the most natural options to support, let's say, collection and processing of data in the clinical trial context. I'll probably state the obvious, but it's important that we all keep in mind that consent under GDPR is something different than consent under the ICF. So having an informed consent form is important, but that is, if you want, one piece that is not really governed by GDPR. So it's the CTR provision and the need to have there in a form that is working well, a proper consent for someone to opt in and get involved into the trial. Consent under GDPR is one piece of of that equation. GDPR has strengthened the consent requirements, and that has kind of complexified or led to some difficulties or possible difficulties when you are faced with collecting and obtaining consent in the clinical trial context. If we take the provision of GDPR on consent for specific categories of data, those are located in our 9.2a of the regulation. Basically, what it says is that in order to collect and process those data subject needs to have provided its explicit consent on the processing of personal data for one or more specified purposes. So for the consent to be valid, it should be specific, and that means unbundled and specifically distinguishable from any other matter. And as I just said 1 minute ago, that means also different from the CTA opt-in, if you want, that you are getting using the ICF form. What it also means is that the informed consent and all of the requirements to satisfy, to get and obtain a valid consent under the regulation, it's something different than your requirement or mandatory transparency vis-a-vis the patient, so the data subject, as part of your requirement to deal with your notices, for example. So those are two different things, and it's important to keep them in mind. Why is GDPR introducing some complexity in the clinical trial context? Because now you have that kind of requirement for specific purposes, and of course we know, and even the GDPR acknowledge, that it's not always possible to identify a specific purposes in a clinical trial context. And if you think at specific categories of data, like for example, genomic data, you may even question how you can obtain consent on genomic data that are not only related to one individual, but for example, to a whole of a family or a population. It's getting even more complicated. But what is clear is that data subjects should be allowed to give their consent to at least to certain area of research, and that needs to follow what the regulation considered to be recognized ethical standards. Good news here is that we have some guidelines from the Working Party 29, because as part of their consent guidelines in anticipation of GDPR, they have provided some guidelines on how to deal with that aspect. Basically, what they have said is that you can provide for a consent in phases. So you can open up your requirement or your consent to a number of potential areas, and then the moment you start or the trial is progressing, you can then narrow down your purposes and each time require a specific consent to depending on the phases. That brings its own complexities, and I'll come to that in a second, because as you know, when you are relying on consent, data subject can decide to withdraw their consent at any time, meaning that you will put eventually your trial at risk if someone is at one point just deciding to withdraw his consent. Here as well, what is important to keep in mind or to know is that as part of the GDPR preparation process, we have seen more and more an attempt to advocate that consent might not be the right legal basis for processing patient data. One of the reasons that was expressed by the UK authorities was, for example, the unbalance between the controller and the data subject. And it was considered that the NHS organization were, for example, so powerful that there was an imbalance between the organization seeking the consent and the patient, and that the consent that was expressed was not valid simply because of that imbalance. What is also putting consent at risk is the right to be forgotten and the possibility or the options for data subject to withdraw their consent at any time, putting the trial at risk. For example, if you need to have a specific number of data subjects, or if you need to have data available, that might put your trial at risk. And that is as just it's one of the reasons why we have seen authorities or organizations trying to advocate for other grounds than consent. What is also important to keep in mind is that even if the Working Party 29 guidelines on consent have kind of softened a bit the consent requirement by allowing, as I said a minute ago, the possibility to get consent on a kind of rollover basis, narrowing down per phase of research. What is for sure is that data subjects, so patients, should have always the right to withdraw their consent. That is something that is non-negotiable, if you want, and that is something people should always get as a right. There has been some confusion, and I'm happy to discuss that in more details if we have time, about the kind of consequence of the withdrawal of consent on past data. Because as a matter of principle, by the time you are collecting data relying on consent, as long as consent is not withdrawn, every data that you have processed up to the time of withdrawal, you should be safe using them. The question of consent withdrawal has an impact only on further processing of the data. But I can come to that in more details if you have some questions. Then, if we cannot rely on consent, or we saw that consent brings its own complexities, what kind of other grounds can we have to collect and process personal data as part of a clinical trial? You have some other grounds that are available in the regulation. Amongst those grounds, you have the collecting or the processing of personal data as part of public interest or public interest in the area of public health or scientific research. If you go to and look to see of what scientific research is all about, you have some definition or indication in some of the recitals of the regulation, and that covers, for example, technological development, fundamental research, applied research, and also privately funded research. So there has been question on whether or not that should be available to commercial research. The understanding so far is that it's probably the case, even though that also comes with its own requirements and boundaries. One of the boundaries or one of the benefits of relying on that ground is that member states or union law, can restrict some of the rights of data subjects when you are relying on that legal ground. So, for example, people won't have an option to withdraw consent simply because you are not using consent as the legal ground. In addition, some of their rights of access, for example, can also be limited because of the specific legal ground you are using. As I said, it's subject to some safeguards. So in order to use and rely on that legal ground, you will need to show and demonstrate that you are using technical and have organization measures in place to respect things like the principle of data minimization. So trying to mitigate the number and the number of personal data you are using, and also relying as much as possible on pseudonymization or even anonymization when it's possible. To sum up on the legal basis for processing, GDPR is bringing its own concern simply because the way consent is structured, built up, brings more challenge than before to obtain a valid consent and to deal with things like the withdrawal of consent. There are other options that might be available. And for example, there are even EU or groups working at EU level to try to advocate for extended guidelines on those topics to see or to get more clarity on the legal grounds to be used. But here as well, what we see is a diverging approach amongst the member states, with, for example, some authorities considering that consent is still the best options for health data, whilst some others will be advocating for other type of legal ground. And I think I'll pause here and take questions on legal basis. If Matthew is there.
Yes, Matthew is there. I was just reading the last question to come in there. We'll start off with some easier ones, namely, is the informed consent regulated by the EU CTR, the clinical trial regulation, instead of GDPR? And does GDPR add anything extra to the informed consent form? Has it made it more complicated, for instance?
Yeah, so that's a very good question, and so I try to make it clear that it's two different things. So what should be included in an informed consent form is something that is CTR centric, if you want, and probably it's not really the CTR who will govern it, although the annex, for example, include a lot of mentions that are necessary for that specific form, but you probably will also need to comply with some of the requirement of the ethical committees and everything. And then, so that's one piece. And then if you are using consent as the legal ground for processing, or if you are using another legal ground, like scientific research, then you will need to factor that aspect into your documentation as of your clinical trials. But it's two different things that needs to fit into two different purposes. And you cannot just bundle everything in one go and pretend that you have then complied with everything. That's not working.
Okay, super. And on the subject of the right to request data, does this also relate to being able to request process data or the mechanism of processing that data?
Yeah, so right of amongst the rights that data subjects have, they have kind of multiple ones. So they will have the right to access, so the right to see what type of data are processed. That is typically something that is available for data subject, and it's one of those rights that can be limited by domestic laws. And it's in fact something that is often limited in the health sector, because it's hard, for example, to segment data and then reply to one data subject saying, okay, those are your data, and we will only communicate those data to you. So it's one of the rights that people have. They can try and to enforce them, but then the controller will have an option to investigate and see how complicated it is to reply to that request, and there will be some options to not to reply to such requests.
Okay, so I couldn't theoretically be sneaky enough to request my process data from a clinical trial as a clinical trial participant and be able to reveal the results of the trial.
No, exactly.
Very good. And I mean, you just talked there a little bit about the implication of domestic law. Which countries do you consider to be the most strict in data protection laws? I mean, GDPR set the bare minimum that we see across Europe, and obviously it was up to each country to then possibly take it a step further. Which countries have chosen to do so, and in which way is the most extreme?
Yeah. So first, we are probably still in the learning process there, because a lot of countries have waited after GDPR to implement their own domestic legislation. So just to take an example, Belgium adopted its law on 19th of July or August, and it's on July, and it's only applicable since early September, so it's quite fresh and new. But that being said, it's probably no surprise that those who were already kind of privacy centric are still privacy centric after GDPR day. So if you take France, for example, they still have a number of specific rules in the processing of health data, like notification to the authorities prior to processing activities in the health sectors, maintaining specific list of persons that will have access to the data, etc., etc. So France, Germany, Spain, although we are waiting still from guidelines on the Spanish regulations to come from the Spanish authorities. The usual suspect there are, or those that were already suspect before, probably are still suspect after GDPR.
Super. And now a question actually related more from a patient organization perspective. We've got someone asking about if a patient organization wanted to carry out an anonymous survey cross-border, would GDPR consent be applicable in that situation?
So the question will be, is really consent the best legal ground available to perform anonymized survey? And then even before legal basis, are we really speaking about truly anonymized data? Because if it's truly anonymized data, we are probably not even in the scope of GDPR. But I doubt that in the situation that is contemplated, we will be outside of GDPR, because I suspect what is happening is it's a survey sent to a number of people that are well identified, but the outcome and the result being aggregated and anonymized, but the process in itself will be code and subject to the regulation. Then, so if that's a given, you need to jump on the legal basis. You probably can have consent as one of the legal bases, although that comes with a number of mandatory steps, if you want, because you need to be able to collect the consent, show that you have provided those data subjects with the right level of information to have a valid consent, etc., etc. So consent will be one option probably, but you might consider another one, which is legitimate interest, one that we haven't discussed here, but that is also one available under the regulation, as long as we are not speaking about sensitive data.
Super, and a very interesting perspective now, or at least I find it very interesting. Something I've never thought of. Does GDPR and the implementation of GDPR in any way differentiate between data that's gathered through the process of the clinical trials, through the research, and that has actually been provided by the patient themselves?
I'm not sure I got that, Matthew, sorry.
So from what I understand of the question, is data in any way differentiated between those that are provided by the patient upfront, pushed into the database, and those that are gathered throughout the course of a scientific research, for example, a clinical trial? Or is all data treated the same?
Yeah, I don't think that they will hardly differ. So, of course, in that kind of scenario, if you take that, of course, you need to have the patient providing you with some type of data to be able to start the trial, and then you will conduct and the trial will go on up to the time when you will have the outcome of the trial itself. I'm sure that there is a great level of difference between, or some level of difference between the kind of patient data you have collected initially and all of the processing activities that his data has undergo initially and up and every time along the chain, if you want. But I'll say there is not a very big differentiation there. So probably GDPR will apply throughout the chain, and the requirements will depend on who is processing data for what purposes and using which basis. But I don't really see a clear differentiation factors in that situation.
Great. And you offered previously as part of your presentation to possibly expand a little bit on the subject of withdrawal of data. And I think that's particularly interesting to us because, of course, we can all imagine the scenario. We conduct a clinical trial, and in the process of actually analyzing the data, or even perhaps post-analysis, participants of the clinical trial exercise their right to withdraw their data. And of course, the sponsor of the trial are looking to take that data to be used as part of a marketing authorization application. Could you expand on that a little bit?
Yeah, sure. And here, so you need to bear with me, but I'll try to be as clear as possible. But because that really deals with a number of different provisions and interaction between different provisions of the regulation. So first, as I think I mentioned, it's clear that when the legal basis that is used for processing and collecting data is consent, it's clear that the patient has the right at any time to withdraw that consent. That is just an absolute given. There is no derogation at all possible. So it's under 7.3 of the regulation. That is undoubtedly possible for a patient. So at any time within the trial process, he or she can withdraw the consent that was given. The consequence attached to that withdrawal is rather clear also. Basically, it means that at the time he or she is withdrawing his consent, at that time you are losing the legal ground for further processing of his or her data. So if you want, by the time I'm withdrawing consent, for everything you will be doing after that, you need to find another ground if you can. Otherwise, you are not any longer processing data with an available or a proper legal ground.
And what could be other legal grounds? Sorry, just to interrupt there.
Yeah, absolutely. Yeah. So first, there could be other legal grounds, and although here, so we are navigating in a kind of a gray area because there could be other legal ground available, like scientific research and some of those. Although the Working Party 29 in its guidelines said kind of clearly that you cannot have swapping of legal grounds. So you cannot just move from one to the other simply because you are confronted with some challenges. But so if it's built properly, you can still argue or construct an argument saying that for some of the data you are holding, you can still keep processing those data. What is also important is that by the time you withdraw, so as I said, it's kind of questioning the processing, so the further processing, but it shouldn't question all of the processing activity that has been done already. Where you have some more complexities is that when you are using consent as legal ground, amongst the other rights that people have, they have also the right to be forgotten. And that's in Article 17 of the regulation. That means that they can also request you not only to stop processing your data ongoing or later on, but they can request to have all of the past processing, if you want, deleted. There, the good news is that you have the possibility to have member states derogation. So some member states can adopt rules that will limit the right to be forgotten in those circumstances. So where you will be able to say, okay, sorry, in the context of health, I will not allow someone to ask and request to have all of the processing activities performed before being just removed, because that put all of the trial at risk, and I will not accept that. So that is a kind of derogation that member states can adopt for all of the processing activities that have been done up to the time you are withdrawing your consent. Okay?
Okay. Yeah, very good.
Then if we want to finalize and further complexify the things, if you are not using consent, then of course the question is different, because if you are not using consent as legal ground, then you will of course have no question on withdrawal of consent, and even the right to be forgotten will fall in another category, because typically for when you are relying on scientific research as legal ground, that is a right that is not kind of granted by the regulation.
Okay, and forgive my ignorance here on the interplays between national or domestic law, but would it be the domestic law of where the data subject were located, or that of the processor which would take priority in a situation where we might have a further governance by domestic law that might say, actually, the data may remain?
And of course, it will be too easy if it was the one of the processor, so it's the one of the data subject.
Okay, I suspected as much. I think that's very good for the protection of the data of patients who are participating in clinical trials. So that's very good. And that's it, I think, for the questions that I can see right now. I'll just check that we haven't received any more whilst we've been talking. Nope. So I know you had a couple of slides left on data breach. Did you want to address them at all, or should we actually finish here?
No, I'm more than happy to take, as we have, 5 minutes? I'll just maybe provide in those 5 minutes just a very high level lessons learned from data breach. As I think I mentioned, so health data is unfortunately one of the sector and area that is highly subject to potential breach. Meaning that everyone needs to be prepared to effectively deal with a breach situation. I'll just take that slide and try to literally spend 1 minute on each of the topics. I think I mentioned initially that GDPR is important, but there is more than GDPR. I mentioned that initially and covered other regulations that are applicable. Here is a perfect example of the other type of regulation that might also apply. For example, if you are also in the United States, you have HIPAA applicable, and the rules around data breach under HIPAA are completely different than the rules under the GDPR. The same, for example, if you are subject to the NIS, so NIS requirements, the breach notification there are also different than the one under GDPR. So it's important to comply with the GDPR, but it's also even more important to consider all of the possible regulations that are applicable to you. The second one, what we have seen is that when a breach is happening, very often clients are concerned and want to take proactive steps vis-à-vis their authorities to say, okay, we are confronted with a problem, what should we do? That is, of course, very valid because, as we know, GDPR comes with a great focus on accountability, transparency, and that kind of concept. What you should know and realize is that you should only speak with the authorities with some level of caution, because what you tell the authorities is on the record. So there are no off-the-record discussion with authorities, and you are probably better to have your own assessment of whether or not you are confronted with a reportable breach. Then, when you have that comfort, notify the authorities of that breach within the prescribed period, and then eventually start an open discussion with the authorities. There was a report published last week by the French CNIL, who basically was saying that as long as you as controller are notifying the CNIL of a data breach within the required period of time, so the undue delay and maximum 72 hours, at least from now, the CNIL will only send you recommendation, and you will not get fined because you are not dealing properly with the breach. Although if you are failing to report the breach timely, they will go for maximum fines, even kind of straight, and not even consider taking you and giving you some advice on how to report and deal with the breach. So that is something that is important to keep in mind. Then I'll just, because I see I have just 1 minute left, so I'll let you go through the other lessons and just take two more that are not on the slides for the benefit of everyone. First, that's a kind of bonus. So first, breach happens on a Friday, so you should just be aware of that. Since GDPR Day, here in the office, we are even joking about it and questioning whether we will have a Friday without a breach notification. So, and that hasn't happened so far. It happens on a Friday, and you should be prepared to notice of a malware, of an attack on a Friday. And the second one, that is also a kind of bonus, you need to look very carefully on how you treat and deal with subject access requests, because if you are not checking properly the identity of the one making the request, you might just create a breach by sending data out to someone that is not the right person. And that is kind of some cautions that, or some good practices that you all need to factor into the way you are dealing with the breach, to avoid that by complying with one aspect of the regulation, you breach another aspect of the regulation. And I'll finish there, Matthew.
Thank you very much, Charles. It's been an absolutely super webinar. I've learned a lot. I've been very grateful that you've answered some of my own questions, as well as many of our community's questions. So I'd lastly ask you also to pass on our thanks to Diletta for the work that she's done in preparing this, and hopefully see whether we can do a follow-on webinar at some point in the future. Have a nice evening, everyone.